Well, good evening and welcome to tonight's broadcast. We finally made it to the last one here, and most of you hung in there. I just want to make sure everybody saw the last trivia slide, so I'm going to manually move these along. Um, Thought this was a lot of fun. Some of you may have saw this when you were tuning in. Some of you that just tuned in the last couple of minutes probably didn't see it. But the question was, Pastor Stephen has a melodica, or maybe it's melodic, I'm not really sure how you pronounce it, and occasionally plays it. And in case you didn't see it, the answer is that. So I wanted to make sure we emphasized that here as we get started. So again, welcome and thanks for joining us here this evening. It's great to see everybody. This is obviously the week 5, the last of the sessions that we have happening here. So want to I know the moment you've all been waiting for is coming right around the corner, and that's the appearance of George Porter, the man himself. So I promise that we will get to him very soon. But I want to also take this opportunity to thank and recognize Sue George for not only being the producer and running this series of financial courses, but also for Sue's daily work to make Derry Presbyterian Church such a great place. I'm sure you already know this, but during the pandemic, she's been grinding on all cylinders, figuring out how the technology, the live stream, all those things can keep us connected while we can't be together and worshiping in person. And it's really amazing the work that she's done in the last 12 months. So I'd encourage you, if you are so willing to do so, just type something in the chat feature in Zoom here this evening, because she will be able to see it. Nobody else viewing can, except for those of us on the back end here. But I know she would appreciate seeing or reading those thanks and types of gratitude that you put out there. I've been on the AV team for quite a few years now, and every few weeks I'm in the sanctuary on Sunday helping with the stream service, as I was there a couple of days ago. And Sue's knowledge, devotion, all those things have been steadfast and so appreciated. So with the complexity and importance of live streaming, she's only also been able to take one Sunday off, I think, in the last 12 months. So she's also probably a bit tired. But again, Sue, thanks for running the behind the scenes on these sessions and all that you do at Derry. So before we get to the main event, estate planning. We're going to briefly reflect on the importance of financial planning. And also, let me turn it off here. Sorry about that. Okay. Trying to tee up the other slides here. Get there in a moment. There we go. Okay. So we're going to start with talking about some of the importance of financial planning. And with that being said, and I'm still trying to get up to speed here. Okay. There's a lot of things that happen with financial planning, and one of the things I do want to spend just a moment on tonight is a topic that several of you emailed with questions about a few weeks ago, which is how best to choose your financial team. So we're going to jump there in a second. The other reminder that I would also suggest, again, as we've been doing in the past, if you have questions, please do use the chat feature that you have down there in the bottom center, and go ahead and enter any questions you have throughout. George is going to be leading much of tonight's session, so please go ahead and answer or ask some questions in there, and George will do his best to answer those if there's any aimed at anything that I'm talking through, the same type of a thing. So we're going to get started tonight with a simple or a quote with that's going to appear on your screen here momentarily. I'm juggling a couple balls, so stumbling a little bit here. All right, so on your screen right now, you're going to see a quote from Winston Churchill. This is, a great and simple quote that he put out there quite a long time ago. One of my favorite: "He who fails to plan, plans to fail." So with that being said, talking about financial planning and having your financial house in order, it's really critical in many ways. And hopefully over these last 4 to 5 weeks, this has been helpful in either reinforcing it or making it become more of a reality. So as we progress through life, we often go through several of these stages of the pyramid, 3 stages outlined here. And as you progress, that time and wealth goes through there. So starting with that uncertainty, sort of in the earlier stages of life. And then we're in that growing investment stage. And then finally, when we're getting close to or in retirement, managing retirement and your estate. So the next sort of the piece of the puzzle that we're looking at right now, there are quite a few components of financial planning, and we've really covered to some extent all of these over the past 4 to 5 weeks here again. And the question really in the middle that's asked is what's missing? And what I would argue is the answer is you and your team, your financial team. So we're going to look at some of the people that may be on your financial team and also how to make sure everybody is working together. As I mentioned, several of you, I think it was mostly after week 1 or maybe even week 2, reached out with some questions. What are, cost of investing, or what are cost of financial advice and those type of things, or what to look for with an advisor. So what you're going to see here on the screen is sort of more of the 4 typical players that ongoing that you might have in your financial situation. And again, it's important, I think, to pick players that are professionally qualified, can be trusted to always act in your best interest. And, professionals that really know their stuff, they're going to have that expertise. They're going to do this for their living, so they're going to have the time, but also have the resources to help you make those decisions that are best for your situation. So with all that being said, I do have a list of questions that I would encourage you to ask your financial advisor, or any financial advisor you consider in the future, as well as some criteria to consider that I will share with you via email. So it's a document that I'll send out via email in coming days as well. And again, similar to previous discussions, one thing I've been trying to emphasize as these conversations have been going, there's not always a right or wrong answer, but in my opinion, when you're looking for an investment or financial advisor, it's somebody that's well educated in the field, probably somebody that has that credentials, the certified financial planner designation. That's the most standard, the highest level of certification for a financial planner. I believe that's important, as well as always somebody that's required to act in your best interest. And if you've seen or heard the word fiduciary, that is exactly what fiduciary means, that the person is required to act in your best interest. So if we think about it, and if you were tuning in beforehand, saw the trivia slides, doctors, and in this case, attorneys, because that was the question on the slide, doctors and both attorneys do have a fiduciary responsibility, but not all financial advisors do. And in fact, that is our very first poll question. We're going to pull that up here so you can see that. And on your screen right now, you should see a question that reads, according to Tony Robbins' book, Unshakable, what percentage of financial advisors in the US are 100% full-time fiduciaries? So go ahead and put your answer in there, what you believe the correct answer is, and we'll pull it up here momentarily. But throughout the United States, I think there's about 310,000 different financial advisors out there. Some have to be a fiduciary all the time. Some aren't required to be a fiduciary at any point, and some are sort of floating around in the middle. So go ahead and answer that question if you would. I see a lot of answers coming in, and we have another great crowd tonight. So it's great to see so many people tuning in here for the last week. So I'm going to call the question here and pull this up on the screen. So actually, the vast majority of you did get it right. The answer is less than 5%. So as anybody that hangs their name out there as a financial advisor, less than 5% of them are actually required to be what's referred to as that full-time fiduciary, 100% of the time, under all circumstances. And as I mentioned, from a perspective of the folks, or the positions that are listed there on the page as your financial team, the attorney is the only one that always has to act in that capacity. So, just like if you go, I mentioned doctors as well. So if you go to see a doctor, if you go to see an attorney, you obviously want to be sitting with somebody that's always looking at your best interest, and they're required to. I would argue with a financial advisor, you want to do the same type of a thing. So the other thing, some other things I should say that you would want to consider with selecting people, any of those team members to act in your best interest, is that you should always be in the driver's seat, meaning that you should always be in control of what decisions are being made at that point in time. Of course, work with somebody that you understand. And from that standpoint, when you're in, you want to make sure that they're clear and you know exactly what that's going to be. The next one down says, know how they are compensated. Again, make sure, that either there's no conflicts of interest or you're very aware of what those conflicts of interest are. And then finally, or not finally, understand what that value is. We talked about their expertise, their resources that they have. And then finally, it is that trust factor that you want to work with, making sure that what they are doing is in the best interest of you. So as I mentioned, I will be sharing a resource with you via email in coming days, but it's really crucial, again, to have a solid team people working on your behalf. And that's a perfect segue, because speaking of a solid attorney, well, here's the moment that you've all been waiting for, the arrival of Mr. George Porter himself. So if you don't know George, he's really the best. His bio is at the beginning, the front of the book, the resource that we sent out. And he's had his own practice and working as an attorney in Hershey for many, many, many years. And he's still a young guy. So I'm going to come back later on and I'll moderate some questions as they come in. Again, ask questions as they come in. But George, the show is yours. George, you out there?
I'm here. Yep.
Okay. And you can go ahead and get started. If you can share your video, then they can see you as well. And there you are. Now just unmute yourself and you're in good shape.
Okay. All right. How about that?
There you are. We see you.
All right, great. Right now, Tracy, I still see your polling question on my screen. I don't know if everybody else has that or not.
They do not. You might have to click out of that, George.
Okay. And how would I go about doing that?
Yeah, if you have, there should be an exit.
Exit. Yep.
Yep, and then it should disappear.
Okay. Okay. Great. All right. Well, hello, everybody, and thank you for tuning in. What I'm going to try to do today in an hour in a fairly short time is to acquaint you with an overview of estate planning. And so far, there's been 2 questions, and they've been the same. 2 people would like to hear about the differences and the advantages of a revocable trust and a will. And I'll talk about that at the end. And I'll also appreciate Tracy's comments on that, because I'm sure he has those decisions to make also sometimes. So for estate planning, I think there are 4 parts or 4 prongs of a good estate plan from my perspective. And they are a general durable power of attorney, a healthcare power of attorney, a will, and then also for those assets that have beneficiary designations on them, a properly formed beneficiary clause on those assets, such as IRAs, life insurance, things like that, that you would have beneficiaries on. And I'm going to talk about all of those as we go through tonight. And then, but before we do that, I'd like to talk about 4 things that'll give you a little bit of a background to estate planning. So when we get into the actual documents that I was referring to, you'll have a little bit of a background, and perhaps we'll be able to relate a little better as we go through here. The first background item is the Pennsylvania inheritance tax. There are a lot of questions about, and if you'll flip that, thank you, Tracy. Pennsylvania inheritance tax is a tax that is assessed on all Pennsylvania residents when they pass away. And that's a distinction from the federal estate and gift tax, which we'll talk about in a minute. The Pennsylvania inheritance tax is a tax on the date of death value of a decedent's assets, valued as of the time that they pass away. The rates of that tax vary depending upon the identity of the beneficiary. So you can see on the screen there, spouses and charities are 0%. Children, parents, grandchildren, grandparents, those are called lineal, and they're 4.5%. Siblings are 12%, and then friends and everybody else is 15%. As an aside, I will tell you that financially, this was why gay marriage was a big deal from a budget perspective in the Commonwealth. And that is all those people who before weren't allowed to be married and therefore passed their assets on to their partner when they passed away. And they would have to pay 15% tax. Now that they're able to be married, those transfers are tax-free. So it really, in more ways than one, it was a bonus for gays in Pennsylvania. Certain property is not subject to inheritance tax. Life insurance is not. Real estate, so if you have a vacation home in New Jersey, that's not subject to Pennsylvania real estate. And irrevocable trust, which shouldn't be confused with revocable trust, because that's how the questions have been posed so far. Irrevocable trusts are not subject to Pennsylvania inheritance tax unless the person who creates the trust reserves the right to I'll just call it generally, use the asset. So if you have a house and you put it into an irrevocable trust, but yet you still live in the house, that's still going to be subject to inheritance tax. Similarly, if you give away your house and you still live in your house, if the Department of Revenue knows about it, then that will be subject to inheritance tax also. And we'll get into that a little bit later when we talk about powers of attorney. Assets that are joint tenancy with right of survivorship. So for example, if two people who aren't married have a bank account jointly and they have, say, $10,000 in it, if one of them passes away, half of that money is subject to inheritance tax at the rate of the co-owner who survives. The inheritance tax return is due 9 months from the day a person passes away. And if an estimated payment of inheritance tax is made within 3 months of the date that a person passes away, they receive a 5% discount. So for example, if you pay $1,000 of inheritance tax within 3 months of the time a person passes away, you'll get credit for $1,050, which doesn't sound like much, but many estates owe $200,000–300,000 of dollars. And there, it really does make a difference in the overall cost of the administration of an estate if you're able to make a prepayment. That's all that I wanted to tell you about inheritance tax. Now, Tracy, if you have anything that I should add, let me know, but otherwise we'll just keep going. The federal estate tax is an interesting tax. It's the tax that you hear a lot of misinformation and rumors about. So back in 1998, this was a tax that it was something called a unified credit with $625,000. And it's to be distinguished from the Pennsylvania inheritance tax for several reasons. First of all, as far as the similarity goes, it's a tax, unlike the Pennsylvania inheritance tax, it's a tax on the combined amount of gifts that a person has made during his or her lifetime and the assets that they will transfer at the time of their death. Each person, though, in the United States is now allowed a credit amount of $11,700,000, and a couple is able to double that. So that would be $23,400,000 that they're able to immunize from federal estate tax. So it has become a tax that, as it is supposed to be, is a tax only on the wealthy. In 1998, that amount was actually $625,000, and Congress realized that it had become, rather than a tax on the wealthy, which it was designed to be, it became a tax on the upper middle class. Congress realized that they were part of that group, so they increased it to gradually increased it till now $11,700,000. The tax rate, though, is very high. It starts at 40%. Unlike the Pennsylvania inheritance tax, it includes life insurance, and also, unlike the Pennsylvania inheritance tax, it includes gifts that a person has made during a lifetime. So that's why if somebody comes into my office and says, I want to give away my house valued at $500,000 to my children, will there be any tax on it? My answer is no, there won't be any tax on it, but you must file a gift tax return. And the purpose of that gift tax return is to alert the IRS that you've consumed $500,000 of your total $11,700,000 credit amount. That $15,000 figure there that you see at the bottom of the chart, that's become sort of less relevant since people are able to immunize $11,700,000. Still, each year, a person may give $15,000 to another person, and you can do that to 100 people if you like, but you can do that without having to file a gift tax return. And that's the significance of that $15,000 per person exclusion. And you hear a lot of conversations about that. You know, people think that they're limited in their gifting to a loved one for $15,000, or they'll have to pay tax, and that simply isn't the case. There are other disadvantages or other consequences of gifting that need to be talked about, though, from a gifting context, and we'll talk briefly about that when we just talk about Medicaid planning. Medicaid planning is such a wide topic that we're only going to gloss over it a little bit tonight, but gifting for purposes of Medicaid planning it comes with a danger, and that is if the gift is made within 5 years of the time somebody applies for Medicaid, then that they would be penalized and unable to obtain Medicaid for a short period of time, or a period of time depending upon the amount of the size of the gift. That's kind of a federal estate tax and Medicaid planning are kind of on the opposite ends of the spectrum of estate planning. As you might imagine, federal estate tax only affects the very wealthy. Medicaid planning it affects most of us, and also the less wealthy, we'll say. So, Tracy, anything that I should talk about in federal estate tax there, do you think?
Yeah, just one question for you, George. It says the word portable here. Could you share with the group what that really means and what that's about?
Yeah, that's kind of a revolutionary concept. Back in 1998, well, first I'll say what portable is, and then I'll say why it's revolutionary. Portable means that if one spouse dies, and let's say they only use $100,000 of their unified credit, when their spouse passes away, she may use $11,600,000 unused dollars for the first spouse to die's credit. So they can add them together. Whereas back in 1998, that was not a possibility. And therefore you had perhaps some of you who did estate planning back in the 1900s remember these bypass trust, and they had a different name, spousal trust, but now you see them used with much less frequency. So that's portable. The most significant thing about retirement assets from an estate planning perspective is that they are subject, when a person passes away, to both inheritance tax, and remember, the inheritance tax rate will be dependent upon the identity of the beneficiary who inherits the asset, but also they're laden with income tax, because the money that's been put in these 401ks, IRAs, 403bs, and the like is all pre-tax money. So it's not like the IRS simply says, oh, you know, poor Mr. Jones, he passed away, we're not going to get that income tax anymore. To the contrary, they still want that income tax. And so what will happen is a beneficiary of a retirement asset has some choices to make when they're the beneficiary of the asset. If they go in and let's say a father passes away with $100,000 in an IRA and he leaves his son as the beneficiary of that IRA, if the son simply walks into the Wells Fargo or whatever, wherever that asset is, and says, I'd like to have all the money, that son will have a taxable event in the amount of $100,000 and have to pay income tax at the son's income tax rate on the year that he does that. Alternatively, the son can create an inherited IRA, in which case he'll have 10 years to withdraw that money. And as he withdraws the money, he will pay income tax on the amount that he withdraws. In the meantime, the money in the IRA can grow, but one way or the other, the IRS is still going to get its money. But the significance of the retirement assets, from my perspective, are they're subject to both income tax and inheritance tax. And keep in mind that both of those taxes are assessed at the rate of the beneficiary. Therefore, in my opinion, an IRA is a great vehicle for a charitable donation. So conceivably, let's say a hypothetical person has a bank account with $100,000 in it and an IRA with $100,000, and he knows that he wants to leave $100,000 to his church and $100,000 to his son. The IRA is the much better choice for the gift to the church, because the church will be taxed on it at its rates. Its income tax rate is 0. Inheritance tax rate for a church is 0. And therefore, he gets more bang for his buck. He's gotten $200,000 of effect for his, well, actually, his son would have to pay 4.5% on the bank account. But nevertheless, that's a lot better than his son having to pay income tax on all that as well. So just to keep that in mind, especially when we get to non-probate assets. You see there the beneficiary possibilities that are listed. I think it's a very good idea to have a named beneficiary on a retirement account. I don't like them going into trusts, and I don't, although sometimes it's the right thing to do. Almost never is it proper to not have any beneficiary at all. If that's the case, the default beneficiary becomes the estate, and the estate has much greater limitations on what it may do with a retirement asset from an income tax perspective. So I guess if there's a takeaway here, it would be always have a named beneficiary on your retirement assets. And to the extent that you're interested in making a charitable donation when you pass away, consider using a retirement asset for it. That's all for that slide, unless you have something, Tracy. So the last thing I wanted to talk about by way of background is the difference between probate and non-probate assets. So a probate asset is an asset that is distributed according to the language of a person's will. And a non-probate asset is an asset that's distributed according to a beneficiary designation that a person has installed on one of their assets. Or also another example of a non-probate asset is a joint ownership property. So a couple comments in regard to this, practical comments. So a person could put, let's say, the SPCA on as a beneficiary of a life insurance policy, and they could have a will that leaves everything to their church, let's just say. But because that life insurance policy has a beneficiary designation on it, it will go to the SPCA regardless of the language of the will. In other words, those beneficiary designations trump the language of a will. So more and more, you see people setting up their estate plans, particularly people who have liquidated those assets such as houses and cars. Prime example, people who are in continuing care communities. You see people with $2-3 million, but they have them all in managed accounts, and these accounts all have beneficiary designations. So when they pass away, the money in those accounts just goes directly to the beneficiaries. And in some cases, probate is avoided entirely. The assets that aren't designated like that, either through a joint ownership provision or a payable on death clause or a trust sometimes, those assets will be obedient to the language in a person's will and will be distributed in accordance with that language. And what you often see in this regard is a husband and wife, not always, but often, husbands and wives, very commonly, they own their assets jointly, for example, a house or a bank account or something like that. And then the most common assets that they have with beneficiary designations on would be a retirement asset like an IRA or 401k, maybe a life insurance policy, something like that. So when the first spouse passes away, all of those assets, either by virtue of the beneficiary designation or the joint ownership provision, just slide over to the surviving spouse. And that becomes a fairly fluid and easy process, because there's no inheritance tax, because spouses are taxed at a 0 rate. And there's no need to probate, because all the assets are held either with beneficiary designations on or joint ownership provisions. So if you look in those little estate notices in the newspaper and you see a person, more likely than not, they are the second spouse to pass away. It's oftentimes a failure in planning that results in the necessity to probate the will of the first spouse to pass away. I'd say in my practice, unless there's a good reason not to, if a couple comes in and says that they want to leave everything to one another, usually we can avoid probate for the death of the first spouse. So I guess one other thing I wanted to say here, but just to be abundantly clear, just because you avoid probate doesn't mean you avoid the duty to pay inheritance tax. You can have $3 million in an investment account that's TOD, that stands for transfer on death, to a person's 3 kids. If the owner of that passes away and it goes to the 3 kids, they're still paying 4.5% of inheritance tax on the date of death value of that asset. So that's about all for that one, Tracy, unless you have a comment.
The only thing that I would add there, George, is as George just indicated, this is critical to make sure that your property is titled in the correct way, whether it's to avoid probate or not to avoid probate. And then the previous page, when he's talking about the beneficiary designations, that's looking from a financial advisor seat, where so often we'll see mistakes being made of titles not, assets not being titled correctly, or not having beneficiaries, or not updating beneficiaries. So this is really important information that George has covered.
I agree with it. So now we can move on to our next slide, please, Tracy. So the first of the 4 prongs that I wanted to talk about was a power of attorney. And powers of attorney, as the definition says, is a written document in which an individual, and the person who makes it is called the principal, gives another person, who's called an agent, the authority to act for the principal on the terms and conditions specified in the document. So the 2 players in a power of attorney are the principal, the guy who makes the power of attorney, and the person who is appointed to do the action is called the agent. So that's language that you hear often. People used to say, "Oh, I'm power of attorney for my father," or something like that. Now, probably the correct term would be, "I'm agent for my father under a power of attorney dated December 5th, 2009, or something like that." That's probably the proper way to introduce yourself if you are an agent for somebody under a power of attorney. A power of attorney can be a document of necessity or convenience. The necessities are probably more common than the conveniences, but the necessity might be a person makes a power of attorney in 2009, and then in 2021 becomes incapacitated by reason of dementia or an accident or something like that. And then the document truly becomes a document of necessity, but it can also be of convenience. Somebody might live in Maryland, but want to sell their vacation home in New York. And if they have a power of attorney, they can just call their agent in New York and say, please sell the house. I don't feel like coming to closing. And that can be done. A power of attorney can be specific or general. We're going to talk more about general today. They're more the tool for estate planning. Specific powers of attorney are used for a specific purpose, as the name implies. So, for example, if you just want to appoint an agent for the purpose of selling your house because you don't want to go to closing, that's a specific power of attorney. A general power of attorney, on the other hand, as the name implies, empowers the agent to conduct a broad range of business, not everything, but a broad range of business for the principal. And the next document we'll talk about is the general power of attorney. The general durable power of attorney is, I think, in many ways more important than a will, due to the fact that, well, due to a lot of facts, but if somebody doesn't have a general durable power of attorney and then becomes incapacitated and can't manage their own affairs, it's too late to execute a power of attorney today. In fact, I received a call today from a lady, nice lady, who said, my husband has Alzheimer's disease and I need you to make a power of attorney. And I said, I'm very sorry, I can't do that because a person that has dementia doesn't have the capacity, well, severe dementia, doesn't have the capacity to sign a power of attorney. So the time to do it is before a person is afflicted with dementia or Alzheimer's or something like that, because the alternative for a person who doesn't have a valid power of attorney is to have his loved ones go to court and have a guardianship imposed. And guardianships are burdensome. It's expensive to have one created. You have to go in front of a judge. You have to have a physician certification. And then even after the guardian is appointed, there's burdensome reporting requirements. And there's also significant limitations on what the guardian may or may not do. So I would say the general durable power of attorney is, of the documents that we're going to talk about today, perhaps the most important. And as you can see there, it survives disability. And so if a person makes one in 2009, has dementia in 2020, the document remains in effect. There's no need to have the doctor come in and say, yes, the agent can still act or anything like that. I can tell you that being an agent under a general durable power of attorney, and I've seen some of the people here who are on the viewing this program, and I know they've been through this. General durable power of attorney is a lot of work. It's that person who has to manage the finances, who has to, if a person needs a change in housing from one level of care to another, they have to work that out. They have to be honest. They have to be familiar with all of the principal's assets. It is a very difficult job, and it's nice if you have somebody that you can select, and you can see the characteristics there that I've just listed a few. Certainly, you want honest. You want capable. You have to have somebody who's familiar with finances and is intelligent. And above all, you have to have somebody who's available, because they can be called out at different times. And for any of you who've been through this, you know it. A power of attorney is a creature of statute now in Pennsylvania. And by that, I mean the form that must be used is regulated by statute. There is an acknowledgement that the agent must sign saying that they will always work in the best interest of the principal. I think it's perfectly appropriate to put a provision into the power of attorney addressing that they expect the agent to be compensated. This is especially true if the agent is not a beneficiary of the person's estate. one other thing I did want to point out in regard to these is some financial institutions require their own forms. So you can have a perfectly valid general durable power of attorney created in obedience to the laws of the Commonwealth of Pennsylvania, but still some places, for example, Vanguard, which I have very high regard for, they have their own idiosyncratic form that the principal and the agent must sign so that the agent may access those accounts at Vanguard. I don't know if they absolutely won't accept a general durable power of attorney created by an attorney, but they definitely want you to fill one out that they have. So for those of you who have investments at places like Edward Jones or Ameriprise or Vanguard, I would recommend that you check with them to see if they have a form that they'd like you to use. And if they do, please complete that form in addition to the general durable power of attorney that your attorney would draft for you. Now, this is where we're going to get into briefly Medicaid planning. And this is Medicaid planning is interesting, and it's also complicated. So by way of introduction to this little bullet point here, Medicaid is a federal government program administered through the states. All 50 states have Medicaid. And what it does is it pays for, at least for purposes of this discussion, Medicaid does a lot of things, but for purposes of this discussion, it pays for a person's nursing home care when they run out of money. However, you can't artificially run out of money by simply giving your money away and then claiming that you're now eligible for Medicaid. Around these two characteristics of the Medicaid program has developed an entire field, which is generally called Medicaid planning. And that is the field of trying to preserve a person's assets so that they can give some assets to their loved ones, but still qualify for Medicaid during their lifetime. How that relates to a general durable power of attorney is as follows. Unless you specifically authorize your agent to give your money away, to create a trust for the benefit of somebody other than yourself, or to change the beneficiaries on your assets, your agent is not permitted to do that. However, all three of those authorizations are essential if you want your agent to be able to do Medicaid planning later down the road. Some Medicaid planning is very tricky and very complicated. Some Medicaid planning is pretty simple. I'll give you an example of something that's simple. So let's say we have Mr. and Mrs. Smith, and they own a home. Mr. Smith becomes disabled and he goes into a nursing home and he becomes eligible for Medicaid. So Medicaid pays for his nursing home stay. Simplistically, what you do in that case is you transfer ownership of the house from Mr. and Mrs. Smith into Mrs. Smith. Then you have Mrs. Smith write a new will, leaving the house to her three kids. So therefore, if Mrs. Smith dies first, the house goes to her three kids instead of back to Mr. Smith, which would take him off Medicaid, or at the very least would result in a Medicaid lien being placed on the house after he passed away. So that's about as simple as I can get with Medicaid planning, and even that's complicated. But the takeaway is your agent can't do Medicaid planning without these authorizations. And these are Medicaid planning comes into play for, I would say, both the middle class and the upper middle class. All of, that entire group has to think about this. So the danger of these hot powers, authorizing your agent to give your money away, authorizing your agent to create a trust for the benefit of somebody other than you, authorizing your agent to change your beneficiaries. The danger of it is, of course, misuse. And there's probably no greater source of litigation in estate planning than the misuse of powers of attorney. I've had a case myself where I had to make 23 trips to the Chester County Courthouse to undo an agent who took $500,000 from his father immediately before he died. And so they can be real controversial subjects. So all the more reason to pick somebody who's honest, capable, and available. Any questions on powers of attorney? Tracy, anything you think I should say?
No, I think that you covered it very well. We do have a couple other questions that we'll circle back to here in a little bit, George, but for now I keep plowing ahead.
Okay. All right. May I have the next screen, please? A healthcare power of attorney is another document that I think we all should have, especially if you would want somebody to make healthcare decisions for you. If the person that you desire to make the decision is not somebody who's in your ordinary family constellation, there is a fallback statute called the Healthcare Representative Statute that can act as a substitute for the healthcare power of attorney statute for people who don't have healthcare powers of attorney. But there's a statutory hierarchy of those people who would have the authorization to make healthcare decisions, and it starts for a spouse. And so for those people who would prefer not to have their spouse make end-of-life decisions for them, a healthcare power of attorney is definitely a desired document. But so with the healthcare power of attorney, the principal appoints the agent to make healthcare decisions, but that decision-making authorization only becomes effective when the principal is unable to make a healthcare decision for him or herself. There's no requirement that the principal be terminally ill or unconscious. All that's necessary is the inability to make a healthcare decision. However, the healthcare power of attorney authorizes the agent to obtain the principal's medical records and speak with the principal's physicians without a showing of incapacity. And in that way, it finesses the HIPAA privacy rules and allows the agent to talk to a person's doctor. So, for example, man breaks his leg, asks his wife to go talk to the physician about what the next best thing to do is. With a properly drafted healthcare power of attorney, his wife is able to talk to the physician and finesse the HIPAA rules. Otherwise, technically, the doctor's not supposed to talk to the wife under those circumstances. The agent should be familiar with the wishes of the principal and also, of course, available. And in this regard, there's something I wanted to say here. It'll come back to me in a little bit. But you should have an agent and then an authorized agent, and give a copy of your healthcare power of attorney to the primary care physician. And here, this is what I wanted to say. Down at the bottom where it says agent can make any healthcare decisions the principal can make. This is important for two reasons. It's a segue to the next slide, but that decision-making ability also includes end-of-life decision-making. So even without a living will, which we'll talk about in a minute, and a living will is also called an advance directive. If a principal appoints an agent to make healthcare decisions for the principal in the event of the principal's incapacity, that decision-making ability includes the ability of the agent to withdraw life support if a person is end stage. So we'll talk about that a little bit more at the next slide, but that's I think a healthcare power of attorney, very important document. And if you have one, you should give a copy of it to your primary care physician. The beauty of these integrated health systems now is if you give it to your primary care physician, it gets into your computer records. On a personal level, you know, I remember when my mother was failing, we'd go to the emergency room, they'd bring up her chart, and the first thing you'd see was the healthcare power of attorney. So that authorized the physicians to talk to Albert and me, and it was a very effective document. So the next slide, then the living will is also called an advance directive. The living will is the document really where what you do is you're telling your healthcare agent what treatments you would like or wouldn't like if you were ever unable to make a healthcare decision for yourself and in an end stage. End stage is a term of both law and medicine. But I think generally speaking, it's a medical condition where a person won't be cured with the intervention of medical treatment. All the medical treatment will do is prolong the process of a person passing away at a time when they have a very low or no quality of life. To be effective, the physician has to certify that the person is both incapacitated and in an end stage. And these living wills, they can be mandatory on the part of the agents. The agents have to follow them, or you can say they're only for guidance. You're just trying to familiarize your agent with your wishes in the event that you are end stage or unable to make a healthcare decision. I recommend that everybody have a healthcare power of attorney. I recommend that everybody familiarize their agent with their views toward end of life care. What a living will does is gives the person an opportunity to put it in writing and essentially takes a burden off the healthcare agent to make a very difficult decision. So that's all I really wanted to tell you about a living will. The will, this is the document that has to be in writing. And remember, the will doesn't control non-probate property, that property that has a beneficiary designation or a joint owner on it. But it controls sort of everything that's left over. So in the hypothetical that we talked about before, person has a life insurance policy and an IRA, a house and a car and a bank account, assuming the bank account and those assets don't have a co-owner. If he passes away, the house, the car, and the bank account will be governed by the language of the will. If somebody doesn't have a will, which is quite common, that's called intestacy. And there, the problem with intestacy, you hear these claims that, oh, if you don't have a will, your assets will go to the state. That's true only if you don't have a relative, I think, nearer than a cousin that's alive. Intestacy goes generally first to spouse, then to kids, then to parents, then to children of parents called siblings. And then I think it goes after that, it goes either to cousins or nephews, but I've never had a case in my life that's gone out that far in the intestate statute. Usually there's somebody there to receive the assets of a person who passes away. Nevertheless, it's a good idea to have a will. What you can see, oh, here's something else I wanted to tell you. Children, they often think like they have a right to inherit their parents' assets. They absolutely don't. Any parent can avoid having a child in a will, and the child really has no recourse. They don't have any standing to say that they deserve their parents' assets or anything like that. The only person who can complain about being omitted from the language of a will is a spouse. And if somebody tries to write a will and not put their spouse in, their spouse has the ability to take something called an elective share, which is, for purposes of this conversation, about 1/3 of a decedent's assets. So at the bottom there, you can see requirements. It has to be in writing and signed by the testator. Right now in my office, I have 2 wills that were handwritten and signed, and one of them wasn't even witnessed. And they're both going to be probated. I took them down to the Register of Wills office, and they approved them. So they don't require great formality. although there's a lot of things that you can put in a will that make an estate much easier to administer and also are a much better expression of a testator, that's the person who writes the will, the testator's wishes. So if we could go to the next slide, please. Typically, a will, these are the wills that I prepare. I'm sure other people have different strategies, but basically I start mine with any specific bequest. So for example, if you have a provision that you want to leave your card or your nephew, something like that, maybe a specific monetary gifts to various friends or relatives. And then also you often see charitable bequests listed with a specific monetary amount, and which is interesting. And I think in many ways it's good. If you create a will and you leave a charity as part of the residuary portion of your estate, and we'll get to that in a minute. In other words, like what's left over, that provision in your will that you might see that says all the rest, residue, and remainder of my property and estate, I give, devise, and bequeath to the following people and institutions. That paragraph, if you include a charity in that provision of your will, that automatically triggers the involvement of the Attorney General, which adds two things. It adds a slight layer of complexity to the administration of your estate. By the same token, it also adds a slight level of oversight to the administration of your estate. So there's kind of a good and bad about it. Just something to think about. And there we have that residue clause that I just talked about. Often in wills, you'll see trusts. For example, if you know your beneficiary is, or at least has the chance of being a minor, less than 18 years of age, minor can't own things. So you really have to, if you don't put a trust in, if you don't put a trust provision in, that leaves the minor with the duty to go to court, or his parents to go to court and have guardianship imposed on those assets until the child reaches 18, which is a very young age to turn over assets to. So it's a good idea to have a trust for minors, to somebody to manage their money, maybe give them some as they grow up and as they need it. And then when they reach a certain designated age, common ages are 22, 25, 30, in those groups, any money that's left in the trust is then handed to them. Special needs trust for people who are on various government programs, and the receipt of money would disqualify them from being on those programs. That's the purpose of the special needs trust. Irresponsible person, if you're just afraid the person's going to squander their money, you can put it in trust. Or perhaps either a second marriage, or you're just afraid a person's going to have a bad marriage and then get divorced, and then somehow or other. Now, just to be clear, money that's held in a trust is insulated from a divorce proceeding, but money that's taken out of a trust and put in joint names, or if they take it out and buy a beach house or something like that, that would be subject to a divorce proceeding. I'm probably getting a little farther away here than I need to be, but suffice it to say that trusts are a very flexible device to put into a trust and can really help things out. The most common one, I think, is a trust for minors, and they appear in a great percentage of my wills anytime there's either a minor child or the opportunity to give money to a grandchild if, for example, a child isn't alive, something like that. Also in wills, you see provisions for guardian for minor children, who would raise the children if the parents weren't there. Executor, that's the person who actually administers the estate. Administration of an estate is like running a small business for a closed period of time, usually about a year. The first 3-4 months of that, there's a great flurry of activity. You definitely want somebody who's competent, hardworking, will listen to advice, and it's a very important role. Inheritance tax there, the significance of that is you can put in your will a provision saying that your estate will pay for all of the inheritance tax that results as a result of your death, including the inheritance tax on those assets that have beneficiary designations like IRAs and investment accounts that are transferred on death. Or you can say, No, let the beneficiaries pay the inheritance tax on those assets that they receive. The estate is only going to pay the inheritance tax on those assets that pass through this will. So those are the two treatments that you can have in a will regarding inheritance tax. If you say nothing at all, the estate is only obligated to pay the inheritance tax associated with those assets that process through the will. Trustee, for a child or a grandchild, I typically recommend somebody who's thoroughly familiar with the child and who will be part of his upbringing so that he knows when the child needs money. I think, first of all, these institutional trusts, you know, your Wells Fargo and Bryn Mawr Trust, and I have great respect for Bryn Mawr Trust, but they don't even want to get involved in a trust now. And Tracy, you can help me with this. I think their threshold now is what, $750,000 or $1 million. And most of us don't have that kind of money to set up for a grandchild. So I think it's good to have an individual that has some knowledge of the child that they're disposing money to or distributing money to. So yeah, that's pretty much what I wanted to tell you about a will.
Hey, George, you know, the statistics are that a lot of, especially younger people, don't have a will, last will and testament because they think, well, we don't need it until we're further along in life. But what happens with guardians for minor children? So say a young couple has, you know, minor children in the household and, you know, some type of a common accident that takes, you know, both of the parents out of the situation. If they don't have a will in place, what happens or who makes those decisions of who is the guardian for those minor children?
That would be the orphans court judge of the county court. And you know, that could be the subject of controversy or you know, or it could be the subject of an agreement, but it would be a court matter. So it's good to nominate somebody for that purpose. That to me, for a young couple with children, is probably the most important reason to have a will. Typically, a young couple, their assets are all going to be titled jointly. They're going to be the beneficiary on one another's assets, other than to create a trust for the benefit of their children if they both pass away and to appoint a guardian. The other needs aren't nearly as significant as the needs involving their children.
Yeah. So another question I want to circle back to that was asked earlier by one of the attendees was, you know, when, I think you might be talking about the difference between the will and the irrevocable trust. But if you can work into that, you know, any assets in a revocable trust that you should not put in a revocable trust. I know you and I were talking prior to going live here tonight about the, you know, purpose of revocable trust, and sometimes that, you know, not a lot of people don't put everything into the revocable trust, which sort of defeats the purpose of it. So if you can talk just a little bit about that, whether now or momentarily, that would be great.
Yeah, I'll do my best on that one, and I'll appreciate your input too, Tracy. I think a revocable trust has a place in estate planning. I don't think it's a great device to use for like a total estate plan, because what happens is a person sets up a revocable trust and they'll say, okay, I have this trust during my lifetime. During my lifetime, I'm the beneficiary of this trust, but then when I pass away, it goes to my two daughters, something like that. The problem with a great reliance on a revocable trust like that is people forget to put all of their assets in the revocable trust. And then when they pass away, yes, the assets that have made their way into the revocable trust are distributed to the two daughters, but the other assets that they might have, if they don't have beneficiary designations or co-owners on, they're out there and they're probate assets, and a will has to be probated anyhow. And the other thing about a revocable trust is that it doesn't defeat inheritance tax at all. It's still fully taxable. It's not a protection from creditors during the lifetime of the person who creates the trust, and that person is called a settlor or a testator, no, a settlor. And so I think they're, as far as a lock, stock, and barrel estate plan, they're really not all they're cracked up to be. And the estate planning at Field has recognized that. 10 or 20 years ago, they were all the rage. You saw these attorneys advertising and having little meetings where they'd invite people and give them donuts, and then they'd have them over and they'd charge them $3,000 for a document that really didn't do all that much. And I know because now I'm seeing them. And in fact, right here's one of those books that I'm administering in a state right now. This person, whose name you can't see, died, and he had a house and it was in the trust, but he has about 10 other bank accounts, none of which are in the trust. So we're having to probate his will and administer his estate. Having said all that, I think a revocable trust is a good management technique. And the most common examples of revocable trust in this town, and I'm sure you've come across these, Tracy, are back in the day when Hershey Trust was in the trust business. Everybody who went over there and invested money with Hershey Trust, or everybody that I know, they'd get a little about 3-page revocable trust, which was all they really needed. And it just gave the Hershey Trust the ability to manage their money while they were living. And then when they passed away, it went to the beneficiaries that they named in their trust document. And if they wanted the money back while they were alive, they would just say, give it to me back. But if they went into a nursing home and they needed somebody reliable and skillful to continue to manage their money, they had this trust to do it. And it worked beautifully for many of our residents in this town until the Attorney General told Hershey Trust to get out of the trust business for private clients. And so they're no longer in there, but I would suspect that there are a lot of members of our church who had those trusts, and they worked just fine. They really did. So I think they were a good management tool, but I don't think that the revocable trust concept is truly a great will substitute. There's a lot of other reasons. For example, if you put real estate into it and you have anybody other than a spouse or a sibling or a child named as a beneficiary of your trust, you have to pay transfer tax on the transfer of the real estate going into the trust. So it's I'm not real fond of it. There might be some people out there who still think it's a good idea, but and I think there's a lot of good uses for trust, but the total estate plan encompassed in one trust, I don't really like that idea. Sorry.
Yeah, and that's perfectly fine. And I would just add that, the trust world and the types of trusts. So we had a question about difference between revocable and irrevocable. And it's basically what it sounds like. Revocable trust, you can change that at any point. So if you set up a revocable trust and you put your house or an investment account into that, you can at any point change that out of there. You can revoke that trust, revoke that asset, pull that asset out of the trust. Irrevocable trust, there can be ways to break up the trust, and you get into all kinds of other things where if you really wanted to do it, in some cases you can, some cases you can't. But an irrevocable trust is something you don't want to try, you're not going to change that in the future. So there's a huge complicated world in trust planning. And as everything, as I've said earlier, with everything we've talked about these 4 or 5 weeks, there's no one size fits all scenario. Everything's different. Everybody's situation is different. So, talking through your situation, figure out, are revocable trusts worthwhile? Are they not worthwhile? All those type of things. I guess before I'll ask you to sort of share some of your final thoughts here, and we'll pull up the last slide here, George, is, anything that should not fit into a revocable trust. So if somebody has a revocable trust, any asset that you think should not, no matter what, fit into that?
Well, I would think a retirement asset would be a poor candidate for inclusion in a revocable trust. I don't see any reason that you'd want to do it because you have the ability to put a beneficiary designation on it. And I'm not sure I don't know how, I guess a revocable trust could hold a retirement asset if the revocable trust was still using the social security number of the settlor, but I've never seen it done. Have you?
I have not seen it done either. I'm not sure if you can do it, but it would not
Yeah.
be advisable. That's the only one that comes to my mind too.
Yeah, I don't think it's a good idea. Yeah. Are there any other questions that we should address, Tracy? Oh,
Nothing else out there that you haven't already addressed at some certain point. And again, unfortunately, we're not going to be able to get into depth to a lot of things, but yep. So, George, I would offer maybe if you can finish with some of these closing thoughts that you have.
yeah, just that in a estate plan, if you look at it and you have the assets that are going to pass through a will and the assets that are going to pass through beneficiary designations, they don't have to you don't have to have the same beneficiaries as you do in your will. That's no requirement, but yet your estate plan should be a whole, that coordinates. And so that, if you want to give money to your church and you're going to use your IRA for that, then you probably don't have to make a bequest in your will. Something like that. Unequal treatment of children. I think this deserves special attention. I've seen wills that treat children unequally. Oftentimes there's legitimate reasons to do it, but in the absence of a truly legitimate reason, something like special needs or something like that, what that winds up doing, in my experience, is fracturing the relationship of the children. So I think that if I'm working with somebody and they want to treat their children unequally, I remind them that might be an unintended consequence of that unequal treatment. Adequate funding of an estate. For anybody who's ever been an executor, that the estate administration process takes money, especially if you have real estate that you need to maintain and pay taxes on, pay accountants and the like. So you'd like to have your estate set up so that the executor has money to work with. So if you know that you have an estate full of illiquid assets, it might be a good idea, if you have a small life insurance policy, to make the estate the beneficiary of that life insurance policy, just so the executor has some cash to work with in the meantime until some of those assets are sold. Good idea to provide alternate executors, guardians, and trustees in case when you pass away, the person that you've named either doesn't want to or can't for any reason. And then finally, a notebook. Notebooks are a good thing to assemble. Just so either your agent under your power of attorney or your executor knows where your assets are, things like passwords and things of this nature. And one other thought that just came into my mind, safe deposit boxes at banks are, I'd say 9 times out of 10 more trouble than they're worth. So that's really all I wanted to say.
Well, excellent. Lots of good things. George, I have a question before you completely disappear on us that was asked. A couple actually folks asked this, one at the beginning and one just coming in here a few moments ago. How do, and the question at the beginning include how the financial advisors charge, and I'll comment on that very briefly here momentarily. But how do a lot of attorneys charge? Some charge by an hourly rate for their work. And then some charge sort of by form, by document. What would your thoughts be on that? Is there a better way, or do more charge one way or another, or what are you thinking about that?
I only know how I charge. I really don't know how other attorneys charge for an estate plan. I guess there's really only 2 ways to go about it. You can either go by the hour, or you can tell people what the whole project is going to cost and just go by that. And depending upon the situation, I use either method. If I get involved in something that I can tell is just going to go on and on and on and be a lot of work, and on those cases, I would tend to bill hourly. But in a normal case, where after I meet the people, I can pretty much define the work that I'm going to need to do. In those situations, I'm able to give them a finite price and stick to it. So, but how other lawyers charge, I really don't know.
Yeah, and I've seen both ways as well, from that perspective. It's charging different ways from that perspective. Some even charge on a retainer, an annual retainer model, from that perspective. To answer the question that was asked earlier, about how financial advisors are paid, when managing money, most often a percent of assets. If they're managing the portfolio, some of the brokerage model, we talked a little bit about that, or some, there's some sales commissions that can be involved on that side. So it depends on what type of an advisor. A fiduciary is going to charge typically on assets under management. If they're managing money, if you just want to do a financial planning engagement, and some people will just say, hey, I want to know, can I retire, or I need a financial plan put into place. What's the best way, or how does that work? And for that one, it's typically a flat fee. At least that's how our firm charges, a flat fee on that work, rather than an hourly rate, and sort of getting that surprise at the end of the engagement of here's what it is, from that one. But I think it's a good question for all consumers to always ask anybody you're going to work with, whether it's an accountant, a financial advisor, an attorney, insurance person, how do you get paid, and how, what are those charges, again, so nobody has any surprises at any point in time. So again, I think some important things there. But we're going to close up because I know we're basically out of time. So I just want to again thank George for participating tonight, and has expected tremendous information, George. So that was great. Thank you. Also want to express thanks to George for all of his contributions to Dairy Church over the years. He's been actively involved with stewardship and finance for many, many years. He's been an elder. He's been involved with the property task force in recent years, and just generally an all-around good guy. So again, we appreciate everything you've done here tonight, George, and as well for Dairy Presbyterian over the years. So as we've talked through all this, and this isn't a big commercial to give to Dairy, but I know that Dairy is a special place for most of us tuning in. So it's great to consider the inclusion of Dairy in your plan giving that David Whitenack talked about last week, and your estate planning. Certainly encourage you to think through that. And after all, if you think about it, generations before us at Dairy have done that. It's one of the reasons I think in many ways why the church is thriving today. So don't be afraid to engage either David Whitenack from last week or George from this week with questions as you consider how the best way maybe to do that. There are some resources near the back of the booklet, the very back of the booklet now that we're at the end of the course, that are there for your use. George mentioned the notebook as being some type of a good device. There's a piece called, that I call the personal roadmap, a way that you can really collect all your important personal financial data, as well as a digital asset inventory worksheet. That's something that's becoming more popular with digital assets, and there's information in the book about that. I'm not going to talk really more about that tonight, but and then finally, there's also a checklist to help navigate through the steps when a loved one passes away. At our firm, we often have some clients or some that pass away, and we've often helped work with the attorney that's working with the estate to help that person get through it. So there's a checklist in the booklet for that one. So that pretty much does it. In case you did miss a previous session of any of the 5 that's here, or maybe next week, next Tuesday night, you miss doing this and you just want to restart it and watch them from scratch again. The recordings of each of these sessions are linked in both the weekly e-news that Sue sends out from Dairy Presbyterian, as well as on the church's YouTube channel. So you can find replays there. So again, would like to thank everybody that's responsible for making all of these sessions happen. Big thanks to Stewardship and Finance Committee for sort of sponsoring or putting this out there. Pastor Stephen for his support on this, David Whitenack for his great contribution last week, for George for what he provided here tonight, and again for Sue George sort of running the ship. So it's been a pleasure from my end. If there's any questions or anything that I can help with, or George or David or anybody else that's involved, please don't hesitate to reach out. We're all here to help each other, and we'd be more than happy to talk through or answer any questions that you have. So Again, thank you so much for joining us over these past 5 weeks. Stay safe, stay well, and God bless everybody. Thank you.